next matter to come before the court this morning is State of Ohio versus Ryan Podojil.
Podojil.
Podojil, thank you. Each side will have 15 minutes. The state is waived, so you have 15 minutes with which to present oral argument. We've read the briefs, we're ready to see who you are.
Okay, thank you, Your Honor. Thank you, Your Honor. May it please the court, and Attorney Angie Kelly on behalf of the appellant Ryan Podojil. Mr. Podojil was convicted via a bench trial of 2 counts of theft as charged as felonies of the 5th degree. As we are all aware, theft offenses as a general rule are delineated by the value of the property that you steal. Under Ohio law, RC section 2913.71 specifies specific instances in which a theft offense is enhanced to a felony. Let me be more specific. Theft or receiving stolen property are enhanced to a felony as a result of the type of property that is taken. That's the issue that's here for you today to review. It is simply a question of law, and the review from this court would be de novo as a result of that. 2913.71 provides a printed form for a check or other negotiable instrument that on its face identifies the drawer or maker whose use is designated or identifies the account on which it is to be drawn and has not been executed by the drawer or maker, and the amount is blank. Our position is, reading that statute, the plain language is not, there's no interpretation needed. The plain language is a blank check. It says...
And I get your argument, but I guess, the state replies, and I think it's something that's a little troubling, stumbling block maybe to your argument. Well, then blank check would be redundant. It says the same thing twice. The statute's saying the same thing twice because...
Okay, do you mean because it says check or negotiable instrument? Is that...
Well, the original definition, so you're saying it can't be, my understanding is you're saying everything in that statute just says it's a blank check.
No, it would be a blank, whatever it is. I know, I would assume, my thought process when reading the statute is that they say a check or other negotiable instrument, meaning a money order, a bank check, anything of a similar fashion that's not, kind of covers the whole thing. I think that, yes, it would have to be blank in order for it to be encompassed in the statute, no matter what form it takes.
Okay, so you're saying that any negotiable instrument whatsoever that's not endorsed or made out to anybody?
Correct.
All right, now these particular checks obviously were made out.
Correct.
To a co-employee.
Correct.
Okay. I can't remember if it was in the briefs or not. Did he sign, your defendant, was the allegation he signed his name to get him checked, to get him cash?
On the back,
Mm-hmm.
yes.
He wasn't charged with forgery?
No. I honestly, as trial counsel, I felt the exact same way, and I was waiting for the state to make that amendment at some point in time during the course.
But I'm sitting there, I'm like, well, why wouldn't you? We got a felony then to begin with.
That was my thought process too, Your Honor, but they never charged him with forgery. They proceeded on the theft. They felt that that was the more appropriate
Maybe they wanted
statute.
somebody to look at the statute.
And that could be the case, because I was unable to, I even checked again this morning, unless I'm missing something, I've been unable to find any case that supports their position. Every time that this statute is utilized within the state of Ohio, it says blank check, like it's a given, blank check, blank check. And I think it's logical, given the legislative intent to me would be like a credit card. If I steal a credit card, it's a felony because I can basically use it as much as I want to until I max it out. So it's limitless in its potential, in theory, other than my credit limit.
So because each one of these checks was under the felony amount, or misdemeanor amounts, not felony amounts, your argument is that each one of these is a separate offense of theft, and each of them's only for $700, because that's really all he stole, because he didn't fill in the amount, he just took what he took.
Correct, it would be the same thing to
Well,
me
it
as,
wasn't endorsed a check that was already completely filled out. So it wasn't a blank check, it was a...
completely executed check, and everybody agreed on that.
Endorsed the back and cashed it.
Correct. So to me, it's the same as if I go to Home Depot and I steal $400 worth of merchandise, it's a misdemeanor, because the value is what delineates what the level of the offense is. It's the same thing here. What did he get? He got nearly $700 in cash from cashing 2 checks on 2 separate occasions. Even if you are a
And
little
that's-
off,
and I
I
think
think they're
that's-
each close to that.
I apologize. I
No.
think that's critical too, that it was 2 separate occasions.
Correct. 2 offenses, in my opinion. They did charge him with misdemeanors as well, and the court convicted him of everything. I didn't challenge those because, quite frankly, I don't think there's a real factual dispute in this case, and it would have resolved quite easily if it had been addressed with the state.
Convicted on all 4, then merged into just 2 remaining, correct?
Correct.
I mean, he had no ability to change the amount that he took.
No, no ability. And
A
if,
pre-printed check with the amount was already filled in.
correct. And both the officer who was in charge of the investigation, as well as the victim, the owner of the company, agreed with that on cross-examination. If you look at the transcripts, it's on pages 34 through 35 and 49 through 50. Fully executed check, no signs that it had been in any way manipulated or changed as to the amount, or how it was originally drafted by the employer. And in furtherance, the only other thing that I would point out that I did notice in review of, in the trial court, when he came out and he issued his decision, and he said, on page 3 of the transcripts from the verdict, volume 1, the court came out and he said, it meets the statute, its printed form on its face, did identify the drawer maker, and had not been executed by the drawer maker. The judge said not executed, and that meets the statute. So to me, once again, but it was executed. It's almost as if the court was acknowledging that it needed to not be executed in order to fall under the purview of this statute, and neglected to recognize that these are in fact executed checks. If the court has no other questions, I'll rest on my brief.
Seeing none, thank you very much
Thank
for
you.
arguing today. We take the matter to advise it, issue a written decision, which will be mailed to all sides